Hey everyone, this is Scott Welch with Welch Law, and today's question is, what do I need to make a will? So I recently had this question come in, and I thought about it for a minute, and really it came out to two different categories of things that you need to make a will. The first are the practical items, and then the second are the legal items. So practically, what do we need to make a will? Well, first we need to sit down and have a basic understanding of what our estate looks like. What kind of assets do we have in our possession? Do we have real estate? Do we have 401ks, IRAs, savings accounts, and those types of things? So just understanding the general nature of our bounty is kind of the legal word that we would use there. The second is we'd want to know who we're going to name as our executor, who's going to be the person that's going to bring our will to the probate court and deliver that there. And then we would want to know who our beneficiaries are, of course, who are we leaving stuff to. And then also we want to know, especially if we have minor children, who our guardians would be if we were going to, if something were to happen to us before our children reach the age of 18. So those are kind of the practical considerations of things that you'll want to know before you sit down to start drafting a will. The legal side of the house is a little bit different. On the legal side, there are a few basic requirements in order to make a valid will. The first is that you have to have sound mind. So lawyers call this is testamentary capacity. And basically what it means is that you are of sound enough mind to understand the nature of your bounty, again, going back to that word, the nature of your estate, right? What do we have in it? But also that you have sound enough mind to make these decisions. So that's the first step. The second step is, are you 18 years or older? You have to be at least 18 or be an emancipated minor in order to create a will. And then we have two kind of formalistic requirements. And one of those is that typically the will needs to be in writing, and then also that it should be signed by two witnesses. The witnesses are usually people that are disinterested witnesses, meaning they're not receiving any benefits under the will. And then also what a lot of lawyers will do is we'll also include a self-proving affidavit, and that basically means that those two witnesses sign both the will and the affidavit saying, hey, we were here, the testator, the person who created the will, was a sound mind, wasn't under any sort of duress or coercion, and we witnessed a will being signed on the state. So those are the two main categories, again, the practical category and then also the legal category of what it takes to create a will. So those are the basics, and this is Scott Welch with Welch Law. Have a great day.